that it's essential to safeguard constitutional rights and ensure procedural fairness, but it should not extend to directing how the legislature carries out its internal disciplinary proceedings unless there's clear evidence of procedural defects or breaches of the Constitution. This decision underlines the principle that the judicial's role in impeachment matters is not to take over legislative functions, but to ensure that such processes are conducted in a manner that respects constitutional norms and procedural fairness. It reinforces the idea that while the doctrine of separation of powers is crucial, it does not preclude judicial oversight when fundamental constitutional principles are at risk. It is therefore our finding, based on the above, that the Constitution of Kenya has clearly delineated independent and distinct paths for the three arms of government. Accordingly, this court's intervention in the matter before it is warranted through a very narrow window that allows for oversight in cases where constitutional infractions are alleged in the impeachment process. This position is reinforced by our previous determination that the petitioners have established a prima facie case in the petitions before this court.
And I will handle the third issue, that is whether the conservatory orders in place should be confirmed. We reiterate that we dealt at length with the nature and principles for consideration in applications seeking conservatory orders. That was in ruling number 1, which we delivered some few days ago. We adopt that discussion as part of this ruling by your reference, and suffice to say that the three main principles for consideration are as follows. The first one being that the need for the applicant to demonstrate an arguable prima facie case. The second, whether the public interest will be served or prejudiced by a decision to exercise discretion to grant or deny a conservatory order. And the third is that whether, if an interim conservatory order is not granted, the petition or its substratum will be rendered nugatory. We will consider the said principles as they play out in this matter. On whether prima facie case has been demonstrated, this is a discussion which featured in ruling number 1, where we dealt with the definition and the nature of a prima facie case. We held that such is a case which, and I quote, on the material presented to court, a tribunal properly directing itself will conclude that there exists a right which has apparently been infringed by the opposite party as to call for an explanation or rebuttal from the other, end of quote. See the case of Rao versus First American Bank of Kenya Limited and 2 others. In the said ruling number 1, we went further and said, I quote, in sum, therefore, in determining whether a matter discloses a prima facie case, a court must look at the case as a whole. It must weigh, albeit preliminarily, the pleadings, the factual basis, the respective parties' positions, the remedies sought, and the law. In doing so, a court must be guided by Articles 22, Sub-Article 1, and Article 258, Sub-Article 1 of the Constitution, which provisions are on the right to institute court proceedings whenever a right or fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or is threatened, or when the Constitution has been contravened or is threatened with contravention, end of quote. Upon being satisfied, this court, in the said ruling number 1, rendered itself as follows. I quote again. Applying the above in this matter, and without much ado, we are satisfied that the consolidated petitions raise constitutional issues that require further judicial consideration, end of quote. This court has not deviated from the above position. We reaffirm that the consolidated petitions in cohort number 1 and in cohort number 2 still raise constitutional issues requiring further judicial interrogation. The second issue is whether with public interest consideration. Black's Law Dictionary described public interest as the general welfare of a populace considered as warranting recognition and protection, something in which the public as a whole has stake, especially in something that justifies government regulation. In ruling number 1, we found and held that, quote, public interest tilts in favor of allowing the constitutional process to proceed unhindered, end of quote. To therefore understand how public interest factors into this matter, it is necessary to examine the historical context of the office of the now Deputy President. Naturally, the starting point is the retired 1963 Constitution, which hereinafter will be referring to as the 1963 Constitution. Chapter 2 of the 1963 Constitution addressed the executive, with part 1 thereof focusing on the President and the Vice President. Section 4 of the 1963 Constitution established the office of the President as follows, I quote, there shall be a President of Kenya who shall be the head of state and Commander-in-Chief of the Armed Forces of the Republic, end of quote. Section 6 addressed a vacancy in the office of the President. And I may not go through all that, but it's in the ruling, you'll find it. Section 15 of the 1963 Constitution dealt with the office of the Vice President. This one I will read. Section 15, subsection 1, read as follows, I quote, there shall be a Vice President of Kenya who shall be appointed by the President. Subsection 2, the President shall appoint the Vice President from among the ministers who are elected members of National Assembly, provided that no appointment to the office of Vice President shall be made at any time when the functions of the office of President are being exercised by any person other than the President. Subsection 3, the Vice President in the discharge of his functions. We have emphasized that provision. Subsection 4, the Vice President shall not enter upon the duties of his office unless he has taken and subscribed the oath of allegiance and such oath for the due execution of his office as may be prescribed by Parliament. 5, during his tenure of office, the Vice President shall not hold any office of profit other than those of Vice President, Minister, and the Member of National Assembly.